we're going on a bike ride.
Everybody rise.
Can we handcuff him in front, maybe?
Buddy rise.
Woo! He's got his...
Everybody. This here court.
Fresner, too.
This here court is now in session. Y'all sit down. And we're going to see to it that injustice is done. And we got a trial here, and I have received complaints from all over the United States about a defendant whose name is Richard Scott O.J. Milligan.
Throw away the key.
Way after he gets a fair trial and when he goes to jail. And you don't have any jury trial, no right to that. And you don't have a right to know what the charges are until you hear them. Now, how do you plead? Guilty or not guilty? You want to talk to your lawyer? Not guilty. Not guilty. Let's try the case. Guilty. We're going to try the case to tell the truth.
I thought
Stay there, Nancy.
this is everybody in the family versus Richard Scott Milligan, the defendant. No, all men by these presents at the underside may aggrieved throughout the years have complaints against the defendant requiring trial, conviction, and sentence. Count 1. Over-competitiveness resulting in egregious emotional harm to siblings and particular cousins on repetitive familial engagements. Aggressiveness to the point of violence, continuously directed towards the pursuit of bowling on vacation on rainy days. Win at all costs was heard coming from his mouth. I'd like to call my first witness, Kay Milligan, to the stand.
Witness, come right up here there. Kay Milligan, sit right down here, lady. And you don't need to be sworn at. I've done enough of that.
Kay Milligan, are you a cousin of the defendant?
Yes!
Is it true that you were badgered into going bowling over and over again, as well as rising to an extreme state of competitiveness? Yes, yes, yes. Oh, God, we hated it. And who was responsible? Him. The defendant. His luggage produced these jeans worn in 1974. He's still wearing them. Have you ever seen Richard this thin?
That's short.
Exhibit A. Exhibit B.
Say it ain't so.
This briefcase was found. Law school co-ed gets his first briefcase.
That's cute.
Very
A
incriminating.
significant clue. Thirdly. Since you can see the defendant no longer has any hair of significance found in his luggage.
Let's see it on.
Yeah, put it on. Let's see. Put it on.
Let's see if
Yay!
It's his.
Not recognize his own children.
No.
And more evidence. I found these keys. He maintains a bachelor pad found in his luggage. Impersonating a younger man.
I'd like to cross-examine these children.
Ooh, that's a good idea.
I'd like to hear every single one of your last names. For the record, starting with you. Milligan. Stewart. Stewart. Snaggletooth Stewart.
Oh, the bench fell down.
Yes! Rachel, what's your last name?
Stewart.
Anna, what's your last name? Anna Lee.
Very good. The defendant has a very good lawyer. Ask questions, but that's
Oh,
enough.
I get one.
All right. Our next
This action against Richard Scott Milligan
hereinafter called RSM, whereas he did knowingly violate the 3-mile limit recognized by all developed nations in the territorial waters of Delaware and Maryland, where he did take
do that, okay?
a person at that time, a minor, a person of tender years, named Daniel Bancroft Morse, deep waters, later to be abducted and taken to the boardwalk at Ocean City, Maryland, exposed to corruptive influences, debaucheries, funnel cake, and notorious glow sticks. Is this true? Are you done, sir? Oh, no. Oh, we've got other misdemeanors.
People in Canton, Ohio, who are really quite angry.
Mommy, hi.
This comes from the Ridgewood Homeowners Association of Canton, requesting cease and desist order regarding the use by Richard Scott Milligan of the We Cover You, the 1,000 sensor alarm system at 408 19th Street.
No.
The frequent and repeated arrival of police and fire trucks and equipment at all hours for no purpose is the basis of this complaint.
That's a
The
valid complaint.
neighbors request that there is an immediate disconnect of the We Cover You, the 1,000 sensor alarm system. There will be a 2-week shunning in place starting July 5th. And both must repeat kindergarten and dog training.
Okay, this is a complaint from the 3M Corporation in St. Paul, Minnesota. They paid my way here so I could present this claim. In 1992, in St. Paul, Minnesota, Ramsey County, Minnesota, that is, Mr. Milligan is accused of overindulging in a food buffet intended strictly for 3M employees and their guests after the Final Four basketball game. He took full advantage of the situation, actually
Mommy, why don't
crashing
Daddy get
the
to
party,
take his hands out?
and then having the nerve to discuss Canton, Ohio with 3M's guests. Disgusting. Then he is accused of never paying or even acknowledging receipt of this bill. And I'm going to submit this bill.
That bill will be
as
admitted
the
in
exhibit.
evidence, and the jury may examine
Excuse me.
that. Very
I wasn't the only one,
Do you have any evidence?
No bicycles on the Susquehanna Bridge.
No, 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 no.
I have, first of all, our first piece of evidence. Bailiff, could you get the...
Witness, I saw it all.
Jack.
Okay, she wants you sworn on the Snoopy. Do you swear on Snoopy? I thought she did.
Jack, do you have any more
If
batteries?
you can bring your attention to that night, in 1983, what were you doing on that Saturday morning?
Crossing the bridge, and shortly thereafter we came upon
This puts us in bad shape.
Are you interested in plea bargaining by now?
We might have to go offline on this one.
All right, any other?
Rest our case.
Oh,
From the
that's
east.
very good. Who else?
There's probably numerous other laws he's broken. We
We've
just
received
You just picked a
indictment,
few right up front.
by the grand jury of the Court of No Resort that has a number of counts, and we're going to present these to the jury. One is that with malice aforethought, he willfully, maliciously advantaged his courtesy cousin Hillary by striking the tetherball far above her head, time after time, with utter and complete disregard for her steadfast effort to compete fairly. Are there witnesses here?
Oh, yeah, I saw that. I saw that.
She never touched it once.
Throw that around, honey. That's
All right.
does it say?
With familial indifference to
does
journey
it
to
say
the
then?
family vacation by bicycle. Whilst, I'm going to give that again. Whilst
No,
his betrothed waited patiently upon the upper porch, peering into the sunset for a glimpse of his bedraggled countenance. Are there witnesses to that, Craig?
Yes. She was waiting,
All right.
waiting and waiting. We had a wager
Count number 3.
when he would arrive.
That's right.
Difference
We
to the
did.
opportunities to get a real job, he became a lawyer, and as such preys upon widows and children who are the victims of the gross, incessant negligence of railroads and other malevolent tortfeasors.
Court geezers. Is that court geezers?
Most anything.
Be careful, you're talking about court teaser.
The most recent charge, unknown to some of you but verified by this judge, is that recently, while preparing to tee off on the first hole at Seven Hills Golf Course, he carelessly, recklessly abandoned his golf course on a precipitous slope without engaging the brake.
He did that
Whereupon
at Nassawanga too.
Yes, whereupon the cart careened down the slope, almost striking his law partner, causing mental torture and jeopardizing the collegiality of the whole law firm. Right. I want to be really fair before we hang this defendant, and therefore we're going to give his lawyer a chance to make a final argument here to this jury. You can say whatever you dare say.
Well, it's awful difficult to counter these very difficult charges. But we would like to submit to the court an option to what looks to be a very serious, as I see by the number on his tag here, a very serious penalty. And the idea is that my client would be willing to accept the penalty of being called 40 years old. For this court disallowing the tough charge and penalty you're going to give him for all these very difficult things that people have come forward with. And I ask you to consider this.
Well, let me ask you one question. Are you suggesting that this defendant is willing to admit to that age to all people everywhere?
Yes.
No Jim Morrises? The whole story comes out.
Whole story.
All right, we've heard it now. Ladies and gentlemen of the jury, how do you, first of all, do we need a not guilty verdict? No.
He's guilty.
How many of you say guilty? Let me hear you. Everybody says not guilty. So quiet I can hear the birds. Now the sentence has been proposed here. We had several suggestions. One was a caning. Another was a week in jail with OJ. Of course, there are some other penalties that could be inflicted. But frankly, this judge finds the penalty suggested by counsel for the defendant to be pretty fair. What does this jury think as to whether that's an appropriate sentence to condemn him to 40 years of life?
Aye.
So be it. You are sentenced to being 40 years. And this court is adjourned. Thank you, bailiff, for doing
Happy birthday to you. Happy birthday to you. Happy birthday, little Richard. Happy birthday to you. You're old. He gets 40 whacks.
Let's have some cake.
You're old.
You have no idea how
Oh, wait a minute. We got to get the cake.
You could have had
You're old. Cake, 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 cake.
Tombstone.
Number 40.
Great sinner.
You look like a great Grateful Dead.
Can all the kids back up a
Yeah,
minute?
kids back up.
Kids back up.
Should we sing again? Happy birthday.